On June 9th, 2026, in less than 4 weeks, a new law takes effect in New York that most content creators, brands, and influencers have no idea it even exists. And if you're running brand deals, creating sponsored content, or using AI-generated visuals anywhere in your advertising workflow, it potentially applies to you. The law is called the AI Transparency in Advertising Act. It requires conspicuous disclosure anytime a synthetic performer, an AI-generated human figure, appears in an advertisement. It was signed by Governor Hochul on December 11th, 2025, and is the first law of its kind in the United States. The enforcement date is less than a month away. By the end of this video, you will know exactly what the law requires, who it applies to, where the gaps are, what exemptions are available, what the penalties look like, and what this means for the future of AI in creator content. Quick note, everything I share on this channel is legal information and commentary, not legal advice. If you need legal guidance regarding your situation, you would need to consult a licensed attorney in your jurisdiction. With that being said, I'm Stevie. This is Girl Code of Law. Let's get into it. Let's start with exactly what the law says, because the details do matter. The AI Transparency in Advertising Act amends New York's general business law. It applies to any person or entity that produces or creates advertising content. If that advertising content features a synthetic performer, and the law defines that very specifically, there must be a conspicuous disclosure. So what is a synthetic performer under law? It is a digitally created asset produced using generative AI or a software algorithm that is intended to give the impression of a human performer who is not recognizable as any natural person. So an AI-generated model in a background scene, a virtual human face created to deliver a product pitch, a digitally constructed spokesperson who doesn't actually exist. All of those are examples of synthetic performers under this law. Notice what the law does not cover. It does not cover deep fakes of real identifiable people. That is a separate legal framework. This law specifically covers AI-generated humans who are not based on any real person. The disclosure must be conspicuous, meaning visible and clear at the point of viewing. The law does not specify the exact format. It doesn't tell you what size the text needs to be, what language to use, or where to place it on the screen. That ambiguity is intentional. It provides flexibility, but it also means advertisers and creators are going to have to make judgment calls about what counts as conspicuous until we have case law or regulatory guidance to clarify it. The penalty structure is straightforward. The first violation is a $1,000 civil penalty. Each subsequent violation is $5,000. The penalties attach to the advertiser, the person or entity that produced or created the advertising content, not the platform publishing it. Platforms are explicitly excluded unless they had written notification that the ad contained a synthetic performer and had more than 5 days to fix it. The law was shepherded through the New York legislation with partnership from SAG-AFTRA, the actors union, which has been one of the most aggressive advocates for performer protection in the AI era. Governor Hochul called it common sense regulation that keeps a clear standard in keeping with technology while protecting artists and consumers. Here is where most coverage stops and where creators actually need to pay attention to this legislation. This law applies broadly. It covers brands, agencies, franchises, and local production partners. But critically, it also explicitly covers influencer marketing campaigns. If you are a content creator running a paid brand deal and the content you produce for that deal features an AI-generated human, this law applies to you as the producer of that advertising content. Here's the geographic reach that surprises most people about this legislation. The law does not only apply to New York-based advertisers. It applies to any commercial advertising produced for distribution in New York or to New York consumers, including digital targeting. If you are producing content in Toronto, LA, or London even, and that content is digitally targeted to New York consumers, you are potentially within the scope of the legislation. That is significant for creators with national or international brand deals. Digital advertising almost always crosses state lines, which means brands running national campaigns using AI-generated models are going to need to adopt standardized disclosure practices across the board, not just for New York, because the alternative is managing different disclosures for different states as more and more states follow New York's lead. Now to the exemptions, because these also matter. The law does not apply to audio-only advertisements. It does not apply where AI is used solely for language translation of a human performer. And it does not apply to advertisement and promotional materials for expressive works, which means movies, television programs, and video games, where the synthetic performer is consistent with their appearance in the underlying work. So a trailer for an animated feature film using an AI-generated character from that film is exempt. A standalone ad featuring a generic AI-generated human pitching a product is not. And there's a companion law worth knowing about. New York also passed the Fashion Workers Act, which requires express written consent from human models before creating or using an AI-generated digital replica of that model. That law covers a different scenario, using AI to replicate a real identifiable person, and is already in effect. Together, these two laws represent New York's attempt to build a comprehensive framework for AI and human identity in advertising. Let's bring this back to what it actually means for you as a creator. The most direct application is to branded content and sponsored posts. If a brand sends you creative assets that include AI-generated human figures and you publish that content as part of a paid partnership, you are the producer of advertising content for the purposes of this law. The disclosure obligation is yours, not just the brand's. That is a shift in how creator contracts need to be written going forward, specifically around who is responsible for ensuring compliance with AI disclosure requirements. The second application is to virtual influencers. The virtual influencer market has been growing rapidly. AI-generated creators with their own followings, brand deals, and content pipelines. If you are a brand using a virtual influencer to advertise in New York, that is exactly what this law was designed to capture. Every piece of advertising content featuring that virtual influencer needs a visible disclosure. The third application is subtler. AI-enhanced human visuals. If a brand is using AI to substantially alter or generate human figures in their advertising creative, even if those figures are loosely based on real people or constructed composites, they may fall under the synthetic performer definition depending on how conspicuously AI-generated they appear. There's also a larger legal question worth tracking. The current administration signed an executive order in December 2025 directing the Department of Justice to challenge state AI laws that conflict with a national regulatory framework. The New York synthetic performer law could potentially face that challenge, though legal analysts have noted that protections for name, image, and likeness rights may fall outside the executive order's scope. Whether this law survives potential federal opposition is an ongoing live question. For now, it goes into effect as of June 9th. New York is a signal. When New York passes a consumer protection law, other states watch. And when a law regulates advertising in New York specifically, national brands typically adopt it nationally, rather than developing and managing a state-by-state variation. This is probably what advertising attorneys are recommending for their clients. They're probably telling them, don't build a disclosure system just for New York, build a universal one that will work for all states. The AI Transparency in Advertising Act is also part of a much larger regulatory shift that we are seeing. It's It sits alongside the Take It Down Act federally, the Elvis Act in Tennessee, rights of publicity expansions in California and Illinois, and the pending No Fakes Act currently working through Congress. Together, these represent a legal framework being constructed, not designed as a unified system, but converging around the same core principle that the commercial use of human identity in the AI era requires consent, transparency, and accountability. For creators, the practical implication is that the question no longer revolves around whether AI regulation will affect how you create and monetize content. It already does affect how you create and monetize content. The question is whether you understand the specific rules in your jurisdiction where your content reaches and whether your contracts with brands reflect who is responsible for compliance when it comes to AI specifically. The creator who understands this landscape has a competitive advantage. Brands are actively looking for creative partners who can navigate AI compliance, not just produce content. Developing that expertise is part of your value proposition now, whether you realize it or not. Here is what you now know after this episode. New York's AI Transparency in Advertising Act takes effect June 9th, 2026. It requires conspicuous disclosure anytime an AI-generated synthetic performer appears in advertising content distributed in New York. And it is the first law of its kind in the United States, meaning every other state is watching what happens next. If you have brand deals involving AI creative, this law is relevant to you starting in June. If you are building AI-assisted content workflows, understanding where these disclosures are required and operating professionally within this framework is something you need to keep up on. If this was useful, share it with a creator and a brand partner in your network, and subscribe because I am tracking exactly how these things play out in real time and what it means for creators in the creator economy. I'm Stevie. This is Girl Code of Law. I'll see you next time.